The first hurdle that you need to overcome in a wage payment dispute is, are you an independent contractor or are you an employee? The reason this matters is because the wage payment law that you can collect under, if you're not an employee, then you can't sue under that claim. It also matters for tax purposes. You're paying your own taxes, and if you're doing that improperly, that can be a problem later on. I think the biggest things that we see with independent contractors versus employees, when we look at that, there's no real brightline test. So it's a balancing of a number of different factors, like how many hours are you working for the employer? Are you able to work for other employers? Did you sign a non-compete? Are you using your own supplies? Are you using your employer's supplies? And so all of those things come together and we balance them, and it helps us make an argument for, are you an independent contractor or are you an employee? And the one thing that is interesting about these distinctions is when you sign a contract, usually in contract law, what the contract says is what the contract says, and you can't wiggle around that. But if you sign a contract that says, yes, I'm an independent contractor, that doesn't apply if that balancing test weighs in favor of being an employee.
Got it. Okay, so a couple things I want to unpack really quick. That was really helpful. One, just for vocabulary purposes, brightline test. I'd never heard that before. What is that in the legal space?
So it's bright line or red line is you'll have these elements or factors, and you have to meet every single one. Or if you meet one of these, it is whatever the test is. You've passed the test, so to speak. A balancing test is where no factor is weighted more than the other. They're all kind of looked together as a whole instead of one thing, just being the deciding factor.
So in a case of like, are you a W-2 or should you be? I should say this better. Are you classified as a W-2 or are you classified as a 1099? It's not the bright line, it's the balancing act. There might be a couple different factors and not one of them necessarily means, oh, you're 100% a W-2. There's a couple different things to consider in that assessment.
Right.
So that obviously adds complication, and people probably need to, I imagine, consult an attorney at the beginning, right? Like if you're an employer, is that part of the practice too? Like is that or part of the recommendation? It's like, hey, talk to the attorneys before you're deciding who's a W-2 or a 1099.
For sure. If you're an employer, you really want to make sure that you are classifying your employees correctly, because if you are not, there's ramifications for that. So the Department of Labor, if there are complaints made by your employee or independent contractor, they start to do an investigation. And if they find out one of your one of your independent contractors is really an employee, well, now maybe they go digging and seeing how many of your workers are classified one or the other. And, not an accountant, not a tax expert by any means, but there are tax ramifications, because when you're 1099, the employer's not paying those taxes, the employee is. And so that can also be an issue as well.
Right, because that might change the evaluation of those taxes, and then also who paid them and when they paid them, and then back pay. I mean, I imagine there's this big domino effect.
So what happens is, if you're an employer, you want, if possible, to classify your employees or your workers. Let's call them your workers so we're not confusing the words. But if you are a employer, you would prefer that your workers be 1099s than W-2s. And the reason for that is, number one, you don't have to pay your own share of taxes for them. So when you are paying somebody W-2, they pay taxes and you pay some taxes also. When they're classified as 1099, they're the only ones paying taxes. So you as the employer avoid those taxes. So that's reason number one why you want to typically classify people as 1099
or people
instead
are
of W-2.
incentivized to do so.
Right, as an employer is incentivized, right. The second big reason is to insulate from liability. So if you're a general contractor or you own a trucking company or whatever, company that you have that might have a lot of liability, what you want to say is, well, hey, this guy doesn't work for me. He's not my employee, so I'm not responsible. I have a agreement with a separate company, or I have an agreement with him individually. He's his own company. So if he got into an accident or he did something wrong, go sue him, don't sue me. And there are some laws that basically allow the contracting party, so the employer in this case, to get out of lawsuits or liability because they say, well, I don't direct my independent contractors.